I'd like to reserve, if I could, 4 minutes.
Sir, you may proceed.
Thank you, Your Honor. My name is Mark Cowan from the Hamlin County Bar, and I represent Mr. Ateem, the appellant. And he was in a 10-year marriage with Dr. Hunt. This was a gay marriage. Dr. Hunt did not tell his children about the marriage. Dr. Hunt was HIV positive for many years, but during this marriage, 10-year marriage, they stayed married. There were no intervening divorces or anything like that. So this becomes important when we look at the estate, because after Dr. Hunt passed away, he did have a will, but that will was drafted many years before the parties were married, even many years before those two parties had met. So under the will that he left, his 3 children by prior marriage were his heirs under that will. Mr. Ateem, in the months before Dr. Hunt actually died, moved some funds from an account of Dr. Hunt to an account that was tenants by the entireties, so that upon the death of Dr. Hunt, those funds would have passed to Mr. Ateem, the appellant, my client. The children filed a lawsuit after the death of Dr. Hunt to set those transfers aside. And that's basically what we're here about today, Your Honor. But it's not, they did reach a settlement on that, but the issue involves taxes on the money that was entered into in the settlement agreement, who pays the taxes on that settlement money. The children filed a lawsuit to set aside the transfers, saying that money really wasn't father's intent to have that money go to his spouse, so those transfers need to be set aside. Mr. Ateem did that on his own, so that those transfers should be set aside and put back to the estate. And they even sued to try to set aside the marriage itself, even though it was for a long duration, over 10 years. And as I said, under the will, had that all succeeded under the will, everything would have gone to the children. But, so Mr. Ateem elected against the will to get his 40% of the estate, because since he'd been married over 9 years, he was entitled just under state law to get the 40%. So he elected against the will for certain things like homestead, 40% of the estate, and the 4 spousal rights that come, that when you elect against a will you can get. So he filed for that, for his 40%. Now, the 2 accounts at issue, they reached a settlement, by the way. They entered into a settlement agreement, and it said that everything will stay in the estate, except I think for about 7 items. 2 of those items are important in this appeal. It was $1.8 million from a brokerage account, and it was $300,000 from an IRA. And the IRA happened to be a Roth IRA, which is good for everybody, because that means that no funds will ever have to be, paid capital gains tax on out of that Roth IRA. So that's really not an issue. There's no tax burden on the Roth IRA, because when that's rolled over, it keeps getting to grow tax exempt. But what is important today is the $1.8 million that they agreed to give Mr. Ateem. And even before this settlement became agreed to, they said, we're going to require that these investment accounts, because stocks go up and down, they said we're going to require that these investment accounts be at least $6.5 million. And so your total out of those would be 2.1. We keep 4.4. So the accounts did measure up to that amount. This was a multi-million-dollar estate. So the accounts measured up to the amount. The settlement went through, and Mr. Ateem was supposed to be entitled to his 2.1 million. So after that happened, the agreement was signed, and the agreement said that all these accounts, I said earlier that they tried to set aside those transfers, because had they not set aside the transfers under Tennessee Tenants by the Entireties law, 100% those funds would have gone to Mr. Ateem, the surviving spouse. But they agreed that those would be estate assets, and all that Mr. Ateem would get would be the $2.1 million and a few other things that aren't relevant here. So there can only be two ways that happens. Either under surviving spouse tenants by the entirety's law, Mr. Ateem owns all that and he pays them the rest, or those transfers are set aside and they're considered estate assets and the estate pays Mr. Ateem. It's got to be one or the other. So to get a full step up in basis, they let the estate own the assets, because that way Mr. Hunt passed away, the assets are stepped up in basis, and they can just pay Mr. Ateem the agreed amount. Well, that didn't happen. They wanted Mr. Ateem, they wanted to not give him cash like it said in his settlement agreement. They wanted to give him these appreciated stock assets so that when he sold them, he wouldn't have 1.8, he would have 1.8 minus all this tax. So this agreement was sanctioned by the court, and agreed order was put down on October 28th, 21, and that settled Mr. Ateem's spousal claims, okay, for 1.8 and the 300,000 and the other items that aren't relevant. So on October 28th, he should have had his 1.8 million. When you have an order that resolves spousal claims, that's a final appealable order under Tennessee law. I don't think anybody's contested that. So that's a final judgment under Tennessee law, which should start accruing post-judgment interest. Because again, he's only entitled to a certain dollar amount. If the stocks appreciate after that, he doesn't get to share in that. All he gets is his amount he agreed to plus his post-judgment interest. Post-judgment interest has been around forever, certainly longer than I've been practicing law, and all final judgments have post-judgment interest. So when Mr. Ateem did not get his stocks, the attorneys wrote letters back and forth and said, hey, why aren't we getting this? And they said that the estate will pay him, but he's got to be responsible for the tax on the assets that are sold to pay him. And we're like, no, we're not agreeing to that. And my law partner refused to sign that. So the estate now curiously argues that it wasn't Mr. Ateem that owned the assets, and it wasn't really the estate. It was a hybrid division of these. Now, I don't know where they get that language, but they mentioned bifurcation. They mentioned division of assets in their brief, I think 15 times. But that's nowhere in the settlement agreement.
What is the ruling of the trial court?
The trial court held that, hey, this was still a joint account, so I'm going to order the assets to be divided, and the 2.1 million of assets, and said we're going to let the estate pick which assets get sold to fund this, but we're going to pretend like it's divided and have the estate sell those assets and have 2.1 million go over here to Mr. Ateem and have the 4.5 or 4.6, whatever's left, over here to the estate. So in other words, he didn't get cash like he bargained for. The trial court said he got these appreciated assets and ordered him to pay the tax on what it sold to pay his own settlement. So that's why we appealed this. And the other thing the court said, I said, well, at least, Your Honor, you've got to give him his post-judgment interest, because and it's not discretionary with the court, all judgments get post-judgment interest. And the court said, no, I'm not going to do that as long as they pay you by a certain date, which I think was 30 days or something. Then there's going to be no post-judgment interest. But by statute, and I think the appellate law is very clear on this, all the way back, the appellate courts have said no, any final judgment like this, even in a divorce judgment, and they argue in their brief that it's a settlement. You don't get post-judgment interest if an order goes down, and that's just not the law. As far as back as Irk v. Irk, Judge Farmer, this court held that no, even in a settlement, you get your post-judgment interest. So there's no law, and they cited no law, and there is no law that says if it's a settlement and it's the court order goes down resolving this approved settlement, that you don't get any kind of post-judgment interest if it's not paid, because it was over 6 months before he got anything. So, and on $1.8 million, that's a lot. So those are the two issues we appealed, that we shouldn't have to pay tax on what the estate sold to pay us, and we shouldn't have to forego our post-judgment interest. There's just a trial court doesn't have discretion to just waive post-judgment interest.
Let me ask you, is there anything in the settlement agreement that indicates that that investment account is going to be liquidated, and then from the liquidation of the account, your client was going to be paid $1.8 million?
No. In fact, that's a good point. We didn't care what they used to pay us. We're just entitled to a dollar amount. But what it said was that of these estate assets, and it listed those two accounts in those list of estate assets, of these estate assets, Mr. Ateem only gets $1.8 million and $300,000.
Well, when you express the value of an investment account, other than expressing it in a dollar amount, what would you express it? How would you express it?
A percentage. If they wanted to pay us part of that account and divide the account, we would get 30% of this account, or 40%, and they would get 60%. See, we don't share in that appreciation. I mean, the market, this was post-COVID, the market kept going up and up and up. And I'd like to come in and argue and say that we did divide that account, but I can't under that agreement.
Well, in that your client was a title owner of that investment account, did your client really have to do anything to retain that $1.8 million? Couldn't it have been left in the account and there would not have been any capital gains taxes at all, would they?
If there had been enough cash to pay him, they could have done that. But I think the problem was there was not enough cash to pay him without selling appreciated assets.
Well, why did they have to sell anything? He's a title owner of the account that has more than $4 million. They could remove whatever they want and left the 1.8, and there would not have been any capital gains taxes because you were not liquidating the account that you owned.
True. But I think the parties wanted to take advantage of the full step up in basis. So it was more advantageous if the estate owns the assets, because then there is a full step up in basis, as opposed to it being tenants by the entirety's account, where there's only a half step up in basis for tax reasons.
Well, it wasn't okay. It was a joint tenancy with right of survivorship.
Yes. So if they didn't set those transfers aside, Mr. Ateem owns it all.
Right.
And he would maybe pay them something if that was part of the settlement, but that wasn't the way it was done. They listed it in the settlement agreement as estate assets.
Yeah. And if he didn't liquidate it all, there'd be no capital gains at that time.
If you didn't liquidate it all, that is true.
So, in connection with the mediated agreement, again, there's no language about how you handle the tax component.
Correct. We were just expecting a check.
Okay, all right.
Any other questions? Thank you. You have your rebuttal time. Yes, ma'am.
Good afternoon, Your Honors. May it please the court, Lindsay Hobbs with the firm of Breeding, Allenzock, Carter, and Crippen here in the Knoxville Bar. I represent the estate of Robert McPhail Hunt Jr. and Robert McPhail Hunt III as the personal representative. I'm going to be addressing the first issue that the appellant has raised regarding the taxation of the account from the settlement agreement, and then my co-counsel Betsy Stibler is going to be addressing the second issue regarding post-judgment.
Have you divided your time up?
I would like to take 10 minutes and she'll take the remaining 5.
Okay, that'd be all right. Go right ahead.
So first I'd like to clarify that the appellant's first issue is not whether he was ordered to pay taxes by the trial court, but was the trial court correct in enforcing the settlement agreement that was entered by the parties, including the tax implications on the respective parties that arose therefrom. At the simplest, this is a contract interpretation case. And the plain language of the settlement agreement, which should be reviewed by the court as a contract, and the totality of the circumstances support affirming the trial court's orders. There is a very long and complex procedural and factual history behind this, but the relevant facts are that the underlying litigation that was filed by the estate and the decedent's children was against the appellant, who purported to be the spouse of the decedent. The appellees sought to claw back funds that he had converted from the sole accounts of the decedent within days prior to the decedent's death, those sole accounts naming the children as beneficiaries of the account. The underlying litigation had multiple claims that were raised both by the children of Dr. Hunt individually and the estate, and that was what was pending at the time of the settlement. Additionally, the appellant did file the petition for elective share in the year's support against the estate. I do want to correct that there was not a suit to set aside the marriage. It was a suit under the Tennessee Adult Protection Act and relief therefrom. But on the eve of trial, regardless, appellant's counsel reached out and stated that the appellant would accept the settlement offer that was previously made, which specified $1.8 million from the joint brokerage account and $300,000 from the Roth IRA. Parties entered into a settlement agreement. The appellant was represented by 2 attorneys at the time. Paragraph 1 of that settlement agreement states that the Hunt children will receive all assets of the estate, excluding the $1.8 million from the joint Vanguard brokerage account and $300,000 from the Roth IRA. I also want to point that paragraph 11 of the settlement agreement states that the appellant's settlement is not to be construed as an admission or concession of responsibility or liability. He specifically negotiated that there was no adjudication of the claims in that settlement agreement in paragraph 11. That contradicts that there was ever any sort of setting aside of transfers of these assets. Additionally, there's nothing in the settlement agreement that ever agrees these are assets of the estate. I do believe that they point in their briefing to several instances where it talks about estate assets. I think in looking at the picture as a whole, understanding he had also filed a petition for year's support and an elective share, the intent is that there is a division of these disputed assets in this civil case, but they didn't want the appellant to then turn around and say that he was still entitled to an elective share of the portion that the children were then receiving. So to be clear, there's nothing in the settlement agreement or the accompanying orders that states that the estate would pay the appellant any amount. It is only termed in all of those as a division of the disputed account, to which the appellant was the sole surviving owner and would have claimed 100% ownership had there not been litigation to stop that. This would also be counterintuitive to the underlying litigation where the appellees were actually the plaintiffs seeking to recover from appellant. So this is not a circumstance where he was suing to recover something, but in fact, the estate and the heirs, the children of the decedent, were the ones that were suing to recover. After all of the settlement documents were done, there were the court orders and the settlement agreement was sent to the financial institution, which said we need cooperation. We need to know how these securities in here are being divided to liquidate and pay these amounts. And it was at that point that Mr. Ateem, the appellant, decided that he wanted to simply have a check written for $1.8 million and would not be participating in payment of taxes. It was that lack of cooperation that necessitated the appellees filing to enforce the settlement agreement as the contract thereunder. The trial court, on hearing the appellee's motion to enforce the settlement agreement, determined that nothing in the agreement shifted the tax burden, and had the appellant prevailed in the litigation, that he would have borne the entire tax burden as the surviving owner of the account. The trial court did authorize the personal representative to designate the division of securities for liquidation. He required them to do it fairly. They did it as a percentage, and that was only because at that time the appellant would not sign off on that division. He did find that the parties would bear their own respective taxes arising from that settlement, since there was nothing in the settlement agreement that specified tax burden would be on one party or the other. It's the clear interpretation of the settlement agreement that supports the trial court's ruling. The plain language is that the appellant is receiving funds from disputed accounts that he created and sought the benefit of as the sole survivor. This is also supported by the entire context of the settlement agreement and the underlying litigation. The parties did not negotiate for the payment of a settlement figure, and the correspondences between counsel are included in the record. So this was not saying, hey, write us a check. The estate writes us a check for this and you get everything else. They said, we will take this much from this account and this much from this account, and the children will take the remaining balance. I think it's also supported by the fact that he is not here arguing about the Roth IRA, which he had no problem taking because there were no tax consequences. It was only when he realized that there would be tax consequences that it became an issue, taking the money from the account of which he was the surviving owner at the time of litigation. This court has had limited opportunity to review the division of assets in a probate context. There is case law in the division of marital assets which would support our position. In Uhas versus Uhas, which is cited in our brief, the court is actually reviewing the allocation of capital gains taxes when one party sought to shift the burden to the other. In that case, this court upheld the trial court's order that made each party liable for their capital gains taxes associated with the property awarded to them. Conversely, there's in Keller v. Gass, which is also cited in the appellee's brief, or the state's brief, excuse me, that the settlement agreement specifically stated one party would not be impacted by tax consequences. And when it was determined that the 401k account at issue in that case would result in tax consequences, the estate said, well, because, or the court said, because this is what it says, that there are no tax consequences, this will have to be liquidated and paid to this person, and they bear the tax consequences.
Did the settlement agreement address any kind of tax consequences?
It did not.
It is my understanding that the settlement agreement only addressed a certain amount, 1.8.
It does specifically list 1.8 from that account. Okay. So it does not say that he will be paid $1.8 million. It states he will receive $1.8 million from the joint Vanguard brokerage account and $300,000 from the Roth IRA.
This language that says that the estate is going to receive all of the assets excluding 1.8 million from Vanguard account. What does that language mean? How are you going to distribute it to the appellant?
Well, and again, at the time that we had all of this done, we sent the court orders and the mediated settlement agreement to the financial institution, and they said, fine, just tell us the division of securities that's going to be liquidated. But in order to liquidate it directly from the account, as you had pointed out with the appellant's counsel, it would go directly to him from an account that he was an owner from. And so they actually required him to move it over into an account and in his name and liquidate it. They also required the estate do the exact same thing. So it was purely a division of that account in which he received the equivalent of the $1.8 million. And I do want to point out that if there were to overturn the trial court's orders at this point to modify, it would be a modification of the negotiated settlement, because there's no shifting of the tax burden in that settlement or adjudication of the claims or anything that states that there's a requirement for the estate to pay him an amount, but a division of the disputed assets from that underlying litigation. And additionally, the appellant did not file to stay the underlying litigation, and the financial institution at the appellant's request has removed those securities into another account. So to overturn it at this point is going to go back and potentially put a greater tax burden on the estate, because there may be tax consequences for what has happened to those funds in the time that it has been in the hands of the appellant. We're not sure where it is, we're not sure what's been done with it, or how the taxes, when taxes were incurred at year end, what that was based on.
Curious question. What is the status at this point of these funds? Are they in the hands of the appellant, or are they still in the estate?
I can only speak to the portion outside of the 1.8 that the estate received, and that is being held in a segregated account with the same financial institution. That financial institution moved the remaining to his. We have no knowledge of what the status of it is.
Has there been a 1099 issued for that 1.8 million?
We have no knowledge. It would be issued through the financial institution, Vanguard.
The Roth account, was the value of the Roth account at the time of the agreement $300,000? Or was it more than that?
It was more than $300,000, yes.
So that $300,000 was distributed to the appellant how?
I know that it has been removed from that Roth account. Again, I do not have the knowledge as to what occurred once he had it removed. It was done at his direction. there are no further questions. I would ask that the order of the trial court be affirmed, and I'll yield the remainder of the time to Ms. Stigler.
Thank you.
Good afternoon, Your Honors. It's a pleasure to see you again.
Yes, ma'am.
Betsy Sibler from the Hamlin County Bar, and I'm just going to touch briefly on the issue of the post-judgment interest. They have argued that post-judgment interest attaches by statute. I would agree that it does when a jury or a judge sitting in trial has returned a verdict. It does not attach to these mediated settlement offers or other negotiated settlement offers, particularly under these circumstances. As Ms. Hobbs pointed out, the estate and the appellee children, whom I represent, actually were the plaintiffs in this matter, and Mr. Ateem was the defendant under some pretty unsavory allegations as to meddling in funds and, as she alluded to, actually changing a beneficiary while Dr. Hunt was in the hospital in a coma hours before his death. That was part of those allegations. So there was a lot going on in this case.
What was the ruling of the trial judge regarding post-judgment interest?
The ruling of the trial judge was that post-judgment interest, that the consideration of that would be stayed for 30 days to give Vanguard the time to transfer those funds. However, the real problem comes in with this party, the estate and the children, being responsible for that, even if this court were to find that it attached, and that is because it was completely out of their hands as to when those funds were distributed. The order dissolving the temporary injunction and instructing Vanguard how to distribute the funds in question was sent to Vanguard right away. There were multiple emails that I believe Mr. Cowan attached in his arguments between counsel back and forth, debating how this was to be handled. The bottom line is that it was a disputed account. Vanguard did not want to maintain any funds or securities in a disputed account. Their answer was both parties need to set up new accounts. We will transfer securities in certain amounts to those accounts, and these parties can be divided and do with what they want to do. The only problem is, as in this day and age, it is very, very difficult to get a large corporate financial institution on the phone, to respond by email, to make these things happen. And it also required the cooperation of Mr. Ateem, which, as she pointed out in her argument, was not forthcoming. Their answer to the question of, can he set this account up so that these funds could be divided, was to begin this argument over whether or not it was dollars or funds, when in fact that probably would have been a moot argument had the securities been quickly transferred and then liquidated. The entire argument is really predicated on the attempt to avoid, any type of capital gains tax. And she did point out that he was represented by two attorneys. His tax attorney, as he is referred to him in this matter, is Rick Swanson. He's very well known for counseling his clients on potential tax implications. This is honestly just buyer's remorse, and asking this court to undo the transfers he made in the months leading up to Dr. Hunt's death so that he doesn't bear any tax burden from those.
Is there a judgment in this case that says that the appellant receives a judgment of a certain dollar amount?
I believe that the judgment was that it approved the agreed order. Is that correct? So, essentially, he entered that agreed order. So I guess that would be considered a quote-unquote judgment. However, the Tennessee Rules of Civil Procedure refer to a judgment in the discussion of post-judgment interest as being a verdict returned by a judge or a jury. So again, that would really upend, as she pointed out, divorce settlements. If we're talking about, that attaches, and people typically have 30 days to get their equity out of a house by selling it, or 120 days. If any type of mediated agreement in that or settlement agreement is subject to post-judgment interest, we're going to have to practice divorce law a whole lot differently.
Who drafted the order on the motion to enforce the settlement agreement?
Counsel for the estate, Your Honor.
Now, in that order, it says that Vanguard is going to distribute the $1.8 million. And looking at the last page of the order, I don't see the language you'd ordinarily see when somebody gets a judgment. It doesn't say a $1.8 million judgment for either party.
And that's because no party really felt like there was a true judgment. It was an agreement. It was a disputed account between the parties, and they agreed on the division of those accounts. And as you'll read in that agreement, to settle all claims. Additionally, there was a consent not to sue one another down the road for further questions in that agreement. So again, a negotiated agreement to settle the claims of plaintiff against defendant. I think it would be a reach to consider that the judgment of a court.
Thank you very much.
Thank you.
Your rebuttal, sir?
Let me address the last point first. Judge Armstrong, you were asking about, is there language in there that looks like a judgment?
Yes.
On October 28th, 2021, this agreed order was entered, and it said that Mr. Ateem will be paid the $2.1 million.
What's the date of that order?
October 28th, 2021.
And then later, there's another order entered in April of 2022.
And that's the one we're appealing.
Right.
Yeah.
And does it have judgment language?
No, it does not. In fact, it said that we don't even get post-judgment interest. So that's why we're appealing those orders. But if you look back to the order that says the money will be paid, that is a judgment. That is in resolution of the spousal claims against the estate. That's in the probate case itself. Not the civil suit they filed. That's in the probate case that says, that where we filed for spousal claims that we're to be paid the 2.1. Now, that's a little bit less than 40% of those accounts. It's more like 32% of those accounts. But that's what we settled for, and that's what we're stuck with. And we don't get any of that appreciation after the settlement date, but we do get a post-judgment interest. I mean, that's only fair. They get all the appreciation of the stocks, but we do get our post-judgment interest, which is going to be considerably less than the appreciation on those stocks, by the way. But Judge Farmer, the case I mentioned earlier, was a divorce case. It says, they reached a settlement. He was the husband, I think, supposed to pay $21,000, and the court said, yeah, you get interest on that. Have to pay post-judgment interest. That's Irk versus Irk. And it's a case, I think, out of the middle section, but it's 1987, Westlaw 16119. And Judge Farmer said, you've got to pay post-judgment interest on that. Wife didn't have the benefit of that money while her appeal was pending. You agreed to pay that. It was an agreement. So the judge put it in the order. And yeah, that draws post-judgment interest. And divorce cases have drawn post-judgment interest on settlements since before I passed the bar. That was the year I started law school, in fact. So I know it's been there a long, long time. I've practiced for over 30 years. So to take the other point.
Looking at your October order, it says that the appellant is entitled to the following assets and the $1.8 million from the Vanguard Group. That's all it says.
Your Honor, right above that, doesn't it say the children will receive all the assets of the estate? So it says right there it's an estate asset. The owner of an asset pays the capital gains tax when it's sold. And it says right there it's an asset of the estate. That's the way the case was settled. We settled it as all that being assets of the estate, and they were just to write us a check.
Well, let me ask, if you thought that by saying it would all go to the estate, why was there no mention of the tax consequences in the settlement agreement? Because you seem to understand now, since it's all going to the estate, somehow the estate is going to be responsible for the capital gains taxes Why wasn't that addressed in the mediated settlement agreement?
Because of the step up in basis. Everybody realized, we certainly realized, we had a tax lawyer on our team, that it's better for Dr. Hunt to own those assets because he gets a fully stepped up basis at his death. Fully, 100%, at his death. If it's considered Mr. Ateem's tenants by the entirety account, it only gets stepped up 50%. 50% for Dr. Hunt, 0 for Mr. Ateem. So it's a better step up in tax basis.
All right, well, all right, and somebody knew that at the time this was negotiated. So why wasn't there another provision in the mediated settlement agreement that says, in return for the stepped-up basis, the estate is going to be responsible for all of the capital gains taxes flowing from the Vanguard account?
Okay, if the court does the math on that $6.5 million, Mr. Ateem, his surviving spouse, would get 40% of that. Now, he might get 40% of the assets as they are and have to pay capital gains tax when he's sold, but he didn't settle for 40%. Assuming that the estate was going to pay the capital gains tax, he took 32% of that money.
Well, I'm just trying to question, why would we have that as an assumption rather than a provision in the settlement agreement that specifically says that?
We thought the provision was in there. We thought it when it said all assets of the estate, that settled the question.
Taxes?
Yes, the owner of an asset is going to pay the capital gains when they're sold. The owner of an asset always pays the capital gains when an asset's sold. So when we listed it as an asset of the estate, that took care of that.
Or you thought it would, anyway.
We thought it would. That's why we're here, Your Honor.
Okay.
But my time's up. Thank you.
More questions?
No.
Thank you. Thank you. Your case now has been submitted to the Court of Appeals. We will thoroughly review this case and put down an opinion and an order on this case within a reasonable period of time. And we want to thank you for both parties for your presentation.